Mr. Speaker, I move that House Bill 1006 be admitted.
You've heard the motion. Is there a second? Chair recognizes Representative Hatfield for discussion.
Thank you, Mr. Speaker, ladies and gentlemen of the House. It is no surprise to this body that we have a DCS problem, which means in the state of Indiana that we're failing to protect the most vulnerable children among us. In the state of Indiana, we have a child protection problem, and House Bill 1006 in many ways seeks to solve that problem. And so I appreciate the underlying bill and the work that the author has done on it. This amendment does three things. It provides much needed oversight that has been attempted but has been ruled not specific enough. One, it requires an annual review of the caseloads of DCS case managers within 60 days after receipt of the caseload report. This report's already required. We're simply asking that there be an annual review of that report. Two, it adds a deadline to the report. When we went in to find these reports, to find out what was going on amongst our Department of Child Services branches around the state, we found that a lot of these reports weren't being submitted. The statute as it reads now requires that report be submitted once every 12 months, but without a deadline, too many of our DCS branches have failed to submit these reports. The Commission has not received them. We also add in this amendment the Commission on Improving the Status of Children to the report recipients, and then we direct the director to hire case managers when current caseloads exceed the limits. I know that most of my colleagues have read the DCS reviews, and so what we know from those reviews is that around the state, our case managers are overloaded. This body has decided that there should be a limit on the amount of families and or children that each case manager is responsible for. We need to ensure that those caseworkers are being respected and that we're protecting these families and children that they're responsible for. Too many of the case managers around the state their workload far exceeds what this body has determined is appropriate. This simply directs the director to hire those case managers. Now, Democrats understand that our directors can't simply just go out and hire. They'd have to come to this body and ask for the funds to do so, but we need to protect the families and the children that are in this system who need us most, and this directs the director to hire these case managers. You might ask, well, if they can already do this, why should we direct them to? I point to a Supreme Court case that came from 2017, Price v. the Department of Child Services. And I'll read to you just in summary, the Indiana Supreme Court has declined to issue a judicial mandate that would require the Department of Child Services to comply with the statutory caseload limits, finding the statute in question does not provide specific compliance guidelines that would warrant issuing a mandate. Helpful, as the court always is, they direct us in this manner. It is not enough, the opinion reads, to speak in mandatory terms such as the department shall ensure and the department shall comply. To be susceptible to a judicial mandate, Section 5 must also compel the performance of a specific act, not just a specific outcome. In current statute, we have laid out the specific outcome. This amendment requires the specific act. It puts us in compliance with the law that we've already tried to establish in the state of Indiana to protect Indiana's most vulnerable children, and I would ask for your support. Thank you.